Welcome back, everybody. So legal practitioners say the ruling of the Commission for Conciliation, Mediation and Arbitration, that's the CCMA, which agreed with the employer that dismissed a worker who refused to be vaccinated is really still to be tested. They say the introduction of mandatory vaccination by companies should be based on whether the application of policy is built on the country's law and the Constitution. Statutory interpretation should concur with aspects such as Section 9 of the Constitution, which deals with the equality clause that guarantees equal protection before the law, and the Supremacy clause found in the Bill of Rights, among others. Johannesburg Bar advocate Peter Makhambeni will be representing the National Black Consumer Council in an application to determine the constitutionality of mandatory vaccination in South Africa. And we have the advocate with us. Great to have you. Thank you so much for joining us.
Well, thank you for having me, ma'am.
It's an absolute pleasure. Let's first begin by getting your reaction to what the CCMA said or handed down in that particular case.
Well, from my vantage point as a practitioner and also as a citizen, I find that ruling rather troubling and worrisome in the sense that this issue first reared its head last year when I think, and if you look at, I think it's paragraph 28 of the CCMA ruling, there's an excerpt there wherein Judge Roland Sutherland's policy of the Joburg High Court with regard to the workplace environment and the attitude towards mandatory vaccine is expressed. And this issue also came up amongst us colleagues. We've discussed it at length, and there are two divergent schools of thought there. The one school of thought is that the learned judge has basically disqualified him and probably even the Joburg High Court from hearing mandatory vaccine cases, because he's basically come out strongly in favor of the mandatory vaccine policy. And another school of thought is that, well, judges are supposed to be objective. But again, when you look at the hard line taken and the language used in that note, which is quoted in the CCMA ruling, that's where the problem lies. One wonders whether objectivity would still be there if a matter is to go to that court. But the problem, and the starting point is this: the minute you talk about mandatory vaccines, right, you run the risk of excluding people who are not vaccinated from public life.
Yeah.
And the question that then creeps, it doesn't even creep into the picture, but it comes into sharp focus, is whether you are fulfilling the constitutional imperative stipulated in Section 9, subsection 2 and 3 of the Constitution's equality clause, because the Constitution doesn't just prescribe formal equality, but it also prescribes substantive and material equality. And where one comes across a state of affairs wherein you've got to do a lot more to ensure that the playing field is level, then you've got to do that. That's a constitutional imperative. It's not negotiable.
Yeah.
And sorry, did you want to come in there with a question?
Yeah, well, I mean, I think these are the kind of questions and the angles that people are wanting to hear. So I just want to come in and ask you a little bit of a brief and quick rundown, if you don't mind, of the case that you're taking to the Con Court and the principles that are grounding the contestations here.
Well, what my client seeks out of the Constitutional Court is to give clarity and also a definite answer with regard to whether or not the president, by basically advocating a vaccine mandate as strongly as he has, and which vaccine mandate policy would have to be given effect to by the Department of Health as well as the Department of Cooperative Governance, has overshot the mark in respect of the ambit and purview of his powers that are enshrined in the Constitution. And because if the court finds that he has overshot the mark by pushing for the vaccine, for the mandatory vaccine mandate to the extent that he has, then it would have to ultimately give a declarator of constitutional invalidity. And if it does that, then the gold rush decision from the CCMA is on shaky grounds, because then those who are going to appeal it or review it in the Labour Court and subsequently probably even the Constitutional Court might have an easier path, if they're going to go that route. But then that's something which the courts will have to decide when that matter gets to court. But back to our matter. So my client wants to know whether the advocacy, the stance taken by the president, which is now being followed by everyone else, and you could see even with Gold Rush now, is congruent with the spirit, tenor, and purport of the Bill of Rights and the Constitution. And in order to answer that question, one would have to start off by looking at the Supremacy Clause, which makes it clear that it is not only legislation that is that must be declared unconstitutional, but even conduct that flies in the face of the rights enshrined in the Bill of Rights must be declared unconstitutional. And then you go to the substantive and material equality clause, which I've just touched upon a few minutes ago. And thereafter, you go and look at the bodily integrity clause, amongst others, in Section 12 of the Constitution. And then, in addition to that, you also have issues such as the freedom of association clause, because it does come into play there with regard to this thing, the rationality. There's also a rationality test, basically. And in the ultimate end, what are you trying to determine here? You're trying to determine whether there is proper compliance with the doctrine of legality, basically. Yeah. That's what it boils down to, stripped to its bare. And again, also to answer these questions, the limitation clause, the exercise there, stipulated in Section 36, subsection 1, has to be performed. And strangely enough, that clause stipulates that the rights contained in the Bill of Rights can only be limited by means of a law of general application. And this is where now things get a bit tricky for the Republic, in the sense, for the Republic's government, in the sense that currently, as we speak, one does not have a law of general application from government. It's only basically discussions which have only commenced. And not only that, if one remembers, I think it was in the penultimate as well as even the ultimate address of our national family meetings, which are chaired by the president, that it was alluded to that a decision in respect of the mandatory vaccine program would only be made at the end of January. And as you and I sit here and talk, it's the 28th of January and nothing has come of it. So
we're still waiting. And we need
we're still waiting for that.
Decisions.
So
indeed.
And that brings into sharp focus the following question. If there is no law of general application, how did Gold Rush come about?
And that's the reality. And I mean, this is where we sit right now, is that this we know is going to go very, very far. And this certainly, I'm sure, is not the first case that's going to sit before courts. And I mean, you are representing currently...
To the best of my
To the best of your knowledge,
and there's a case coming up in the Free State High Court on Tuesday. And I think it relates to the University of Free State, if I have it correctly, because it's, from what I know, the second applicant in our matter is litigating in Free State on Tuesday.
Okay, so, and that's also the mandatory vaccination at university campuses, which is obviously under the spotlight.
That's a thing, and
it's a big, this is a big debate, and it's a very divisive debate as well. I mean, you representing the Business Council as your client, which shows that there is a lot of division over the matter, because it is also businesses that are pushing forward with this mandatory vaccination. And as you say, the country hasn't even spoken to it yet. So on the legal side, when a country has not said that vaccines are mandatory, and yet a company that you work for says, this is mandatory in our company, you either get vaccinated or you're out. Is it fair? Are they allowed to do that?
Strictly speaking, they're not. Strictly speaking, they're not, because they're supposed to wait for the legislature to come up with the necessary law to regulate the vaccine program, rather the mandatory vaccine policy. And if the vaccine policy is not regulated, then you cannot do what I think a good example here is what happened to Sir Lewis Hamilton at the Abu Dhabi Grand Prix on the 12th of December. You cannot make up laws on the fly as you go along in the same way that Michael Massey did. And that's basically what's happening.
Yeah. A good example. But the reality is that where are they getting this from then? When we look at this, if we have not accepted any, the South African government hasn't said anything with regard to that, what framework is being used by business right now to determine mandatory vaccination?
Well, the problem lies also in what I would call at times the inconsistent application of the Disaster Management Act, wherein you find that people advocate a certain stance, advocate in favor of a certain stance, a certain and particular stance, and then without that stance having been properly taken through the legislative process, and owing to the fact that there isn't sufficient accountability because there's a lack of sufficient accountability in Parliament, because the Disaster Management Act, basically, it's meant for emergency and pandemic natural disasters such as the pandemic at this moment. But the problem with it is that it doesn't guarantee sufficient checks and balances. And now, once the advancement of a particular stance is taken, certain people start accepting that it's policy and it's the order of the day, when in fact it is not even the order of the day. Because if you look at it, let's deal with the issue of what is supposed to be the purpose behind the vaccine mandate. The purpose behind it is supposed to be the act of, the goal of reducing transmission of COVID-19, the goal of reducing the risk of people contracting the virus. Now, if you rewind back to the time before we had the vaccine, Leanne, what did we have in place? We had COVID-19 protocols that did a good job, especially in the way South Africa applied them in the initial phases, because we were even better than the United States in slowing the transmission of COVID-19 cases. And it was during the course of the massive waves where the cases would spiral out of control. But once the waves eased, then you had those protocols under control, and then we were even brought down to level 2 and in some instances level 1. So those who choose not to be vaccinated, again, retain a right to equality and equal protection under the law. And the other consideration, in my view, that comes into the picture is everyone, including the South African government, is complaining about an economy that is battered and the record unemployment rate. Yet, people out of work.
Because they're not vaccinated.
And when you can find a delicate balance, and if you read Section 36 of the Constitution, this is what we signed up for in 1993 when we adopted the 93 Constitution, which was then superseded by the current Constitution. Whatever we do, and as far as there were competing rights in the Bill of Rights, a delicate balance had to be struck. And these are the things that people such as Ismail Mohammed, Arthur Chaskelson, John Didcot, said when the Constitutional Court was initially established. And not forgetting a lot of the great body of work, guys such as Chief Justice Pius Langa and Judge Madalla and Judge Sachs have put forward in that court, when they were working in those foundation years of the existence of the Constitutional Court. So there is more than enough of a body of work to enable this court, to the Constitutional Court, to basically strike the necessary balance in the best interests of all South Africans.
And on that note, I have to leave it, but it's been just very informative speaking to you, Advocate. Thank you. Thanks for bringing your knowledge to the table here and really taking it from the legal perspective of this ruling and going forward. An interesting one happening in the Free State. This, of course, is going to be at the Constitutional Court, the one that we've been talking about, and of course that CCMA ruling as well. So, Advocate, the Johannesburg Bar Advocate Peter Makhambeni discussing mandatory vaccination in the workplace.